Tenants filing lawsuits sucks. Today, not only are we going to talk about my personal experience related to lawsuits, but we're going to talk about the top 8 reasons why landlords and tenants unfortunately end up deciding to sue each other and what you can do to prevent getting sued or having to do the suing. Ultimately, there tends to be nothing more stressful than a legal battle, and preventing a legal battle can be the best cure in any lawsuit. With that said, let's get into the top 8 reasons and break down why things tend to break down in real estate investing. Then we'll also go into some personal experiences and commentary that will also help get your landlording, investing, or even tenanting to the next level. Common lawsuit number 1, the tenant suggesting to the landlord, hey, you know what? Instead of me paying my last month's rent, why don't you just use my security deposit and I'll live out my security deposit. Unfortunately, this can oftentimes invite a lawsuit because if there are security deposit deductions that need to be made by the landlord after the tenant moves out, and there's no security deposit left, the landlord might have a claim to file a lawsuit against the tenant. Now, a lot of areas around the country to sort of prevent this have started collecting from tenants the first month's rent, the security deposit, and the last month's rent. But this becomes increasingly expensive for people to actually move into properties. It makes properties very unaffordable to move into. But not only that, a lot of tenants have turned around and said, you know what? I'm just living out my last 2 months for free because I've already paid you the security deposit. You could use that for the second to last month, and I've already paid you the last month's rent. So I'm just going to live that out. But let me break down why this is actually a bad idea for both the landlord to allow and the tenant to suggest, and how it could lead to lawsuits. We'll also, in step 1, sort of break down how lawsuits can happen even if you think it's not going to make sense for a landlord to sue you for $1,000. You might be surprised. Then we'll go through the other 7 reasons people get sued. Let's come up with an example here. Let's say a tenant is renting a property for $1,500 and they have a $1,500 security deposit. They end up living out their security deposit and not paying the last month's rent. Now, when they go to move out, they damage 3 doors. The landlord then realizes it's going to cost $1,000 to repair these doors, and the tenant's already moved out. The landlord goes ahead and conducts these repairs and places a new tenant. The landlord, however, doesn't have a security deposit to make any deductions against. Now, the landlord might be tempted to file a lawsuit against the tenant if the tenant doesn't reimburse the landlord those $1,000. This is unfortunately where a lot of people think, well, the landlord's not gonna sue me for $1,000. Are you serious? Who sues anybody for $1,000? And that's usually because a lot of people read their lease agreement and see, oh, well, if there's a dispute, we'll have to go through mediation and arbitration. And usually people realize the fees just to set up mediation and arbitration usually start somewhere between $1,000 to $5,000, sometimes even more, because you oftentimes have to get an attorney on retainer to help you through the paperwork. This is where a lot of people come up with that assumption, they're not gonna sue me for $1,000. But there's usually an exception buried into most lease agreements. Now again, I'm not an attorney, so verify this yourself, but the exception is called small claims court. This is where the landlord can file a small claims lawsuit for sometimes the cost of $50 to $100, and all of a sudden, the tenant is getting sued, and it's only costing the landlord $50 to $100 to file that lawsuit. And generally in small claims, you can't have an attorney present. With a $50 to $100 filing fee and awards of upwards of $5,000 to $10,000, a small claims lawsuit is a very real remedy for both a landlord and a tenant. And living out a security deposit could end up setting up a small claims lawsuit. Avoiding this is the best case scenario, because let's say a tenant doesn't show up to the small claims lawsuit and they end up getting a judgment secured against them, that tenant's credit score could end up taking a hit, as credit bureaus sometimes look for outstanding judgments. This is where the concept of tenant leverage that I talk about in my real estate investing course and my do-it-yourself property management course becomes very, very important. Having tenant leverage means a landlord has leverage over a tenant to where the tenant doesn't want their credit score damaged. This is where obviously if a tenant had, let's say, a $500 credit score, they might not actually care if they get a judgment against them. This would be an example where a landlord doesn't really have tenant leverage, because there's an old saying, you can't get blood from a turnip. But keep in mind, tenant leverage goes both ways. Tenants are usually in possession of a property, which gives them a big upper hand. There's a saying that possession is 9/10 of the law, but the ability to file a small claims lawsuit and affect somebody's credit is also a form of leverage. And usually negotiations come out of both sides having some form of equal leverage. Obviously, avoiding court is the goal, and we'll talk about some methods for avoiding court, but let's go into the next reason where tenants and landlords commonly sue each other, and then later we'll also talk about a security deposit reductions when it's done the proper way and how to do it properly. Now, the second reason lawsuits oftentimes happen are out of disputes of habitability, and this is where we're going to start talking about ways to actually prevent a lawsuit. See, a landlord is required to provide a habitable and safe living space within reason for a tenant. If something breaks, the landlord has an implied warranty that they have to fix it. However, that damage can't be the tenant's fault, and this is oftentimes where disputes can arise. If the tenant damaged something, shouldn't the tenant be the one to fix it? But now, what if that was a heater, or a plumbing issue, or something that would affect habitability? This is where things get messy. And so this is exactly where we're going to talk about prevention, and then we'll talk about the cures for habitability issues. No matter which lawsuit scenario we talk about, the easiest way to avoid a lawsuit is proper communication and proper documentation. Anytime a tenant takes possession of a property or a landlord rents out a property, I highly recommend both sides not only take photos, but also take slow motion video evidence of the property. It's really convenient to be able to still frame a slow motion video and see parts of a house that you ordinarily wouldn't think to look at, like behind a door, or when you open the garage door to see if it functions, did you close it again to make sure there wasn't any kind of crazy funky damage or weird storage in the rafters above the garage? These are common things that people miss, and then they end up getting charged for throwing away old paint that they didn't put there, or damage behind doors that they didn't cause. Photo, video, and sometimes even 360-degree virtual tours are key when it comes to documenting the condition of a property. Think about it. Who's going to have a better time convincing a judge of the before and after condition of a property? The person with a 3D virtual tour showing a beautiful move-in ready property before and a damaged property after, or somebody with no photo documentation and just something like, well, it was already damaged when I moved in. It's a slam dunk, and this is where prevention solves the most lawsuits. If you have the proper photographic or video evidence and you think something is wrong, say it. If you're a tenant, say it to the landlord. If you're a landlord, document to the tenant. Here are two quick examples. A landlord might say to a tenant, hey tenant, we noticed that there's actually a defect with this screen door. We're letting you know we're aware of it. We don't have any plans to fix it. Let us know though if it becomes a problem. That is a proactive landlord. Much like a tenant could say, hey, I noticed that there's this long corrugated dryer vent in the garage. I don't believe that's to code. Is there any way we can verify whether it is or isn't? Now, this isn't to suggest that tenants need to know what building codes are, or landlords aren't responsible for trying to do the best to make sure that everything is up to code. But keep in mind, there are usually red flags when things are funky or janky. And if you just send a quick email, not only do you document your position and evidence the condition of a property the way it is when you rented it or when you took possession of the property, but you can oftentimes solve problems that otherwise turn into disasters. My best advice for this is the same advice that I give people in my real estate investing course. It's really useful to have your CPA or insurance agent's email memorized, or at least the first part of it memorized, so it pops up when you pull out your phone and you start drafting an email. The same is what you should do for your landlord. So that way, if you're walking down the street and you think, you know what, ooh, I gotta ask my landlord, my CPA, my insurance agent about something. Stop. Don't procrastinate. Pull out your phone, send off that 1 or 2 line email, attach a picture, get it out right there, right away. Don't wait. That will help prevent the vast majority of your headaches. Communication. This also goes for text messages and phone calls. It doesn't hurt to send a follow-up email and say, hey, just confirming we talked about this, and landlord, you're planning on doing this, or tenant, you're planning on doing this. Thanks so much for your time on the phone. Talk to you later. Whatever. You can screenshot text messages. Documentation is key. Now let's make an example. Let's say a heater goes out and the tenant did not do anything wrong. However, the landlord just doesn't respond for some reason. Who knows? They're on vacation or they say they'll take care of it, and a reasonable period of time goes by. Say 48 hours goes by, and the tenant's freezing and doesn't have a functioning heater. The tenant has a few different remedies. The first is called repair and deduct, and there are limitations to all of these, so obviously consult an attorney before you just do these. But there are cases where a tenant can hire a heating and air technician, repair the problem, and just deduct that invoiced bill amount from the rent. The second option is the tenant could decide to just leave the property and stop paying rent. This usually means, though, you actually have to leave the property. You can't just stop paying rent and keep staying in the property. That is, of course, unless you can take advantage of the third option. The third option is usually reserved for very severe cases and usually only partial issues. Let's say there's a roof leak that has damaged one room, and it's a 3-bedroom house. Now, nobody can sleep in that third room. A tenant might be able to deduct the rent for that proportion of the house, be it 1/3 or whatever proportion is deemed reasonable in that case, and not pay that portion of rent. It's a very, very difficult burden for a tenant to say, I'm staying in the property and I'm not paying rent because you're not fixing something. Usually, that's not the best way to go about it. And if as a tenant you ever find yourself in that situation, ask yourself, can you repair and deduct within the limitations? Can you get proper communication to solve it? And can you get even an agreed text that says the landlord authorizes you to hire somebody? Or are you just going to move and leave? But be very careful about staying in a property without paying. Now keep in mind, communication is so key because habitability issues are one of the common reasons lawsuits occur. If a tenant has to abandon a property because the landlord isn't fixing it, that's bad because the tenant now incurs moving costs, and that sets up, guess what? Small claims liability. The same could be true for mold or lead or other issues that usually just aren't handled because of poor communication. Now here's a common one that pretty much everybody hears about. I also reached out to course members before recording this video, and I asked course members, hey, what are your most curious questions when it comes to issues between landlords and tenants? And everybody seems interested in knowing, oh my gosh, do I as a landlord need to get a limited liability company to limit my liability? Should I get an umbrella policy to limit my liability in case, number 3, a tenant slips and falls and sues me? Some sort of personal injury lawsuit. Let's delve into that. First things first, it's important to determine who's the one getting sued. If a tenant slips and falls, they might sue the landlord and the owner for negligence. Maybe there was a crooked staircase or a broken railing or some reason the tenant is blaming that fall on the landlord, the property manager, the owner. And usually what happens is everybody gets sued. Generally, the owner of the property will then file an insurance claim to try to litigate or settle with the tenant. This is where it's also important that if you have a property manager, that you add the property manager as an additionally insured party, so the owner's insurance also fights on behalf of the property manager. Now, insurance is not only good for the landlord, insurance is also good for the tenant, because if the tenant is legitimately seeking, let's say, $50,000 in damages, they're probably going to get that a lot faster from an insurance company than from a landlord that doesn't have the proper insurance. In my legal experience, and I'm not suggesting I'm a lawyer, I'm suggesting I've hired lawyers because of legal issues. Let me tell you, having the proper insurance is the first and oftentimes the best line of defense. In this case, it's important as a landlord to always make sure that the landlord has the proper renter's insurance in place. Oftentimes, these insurance policies can have a limit of, let's say, $300,000 in damages. This is where sometimes landlords, and I encourage this, will increase that limit on maybe multiple of their properties via an umbrella insurance policy, which could extend this coverage to $1 million to $5 to $10 million in coverage. That's really, really good, obviously, as long as the insurance company pays. If the insurance company doesn't, a lot of people believe that, well, I'll have a limited liability company then, and I'll use that to protect myself from damages. Now, I've recently published some very, very detailed lectures on should you have a limited liability company in the real estate investing course. You can check out the coupon code for that linked below. And by the way, here's some feedback from a course member who says he's halfway through the course and he's taken over 80 pages of notes, and his wife says, "Oh my gosh, you're taking more notes on Kevin's course than you did when you were in college." But anyway, while I have very detailed lectures on limited liability companies, let's just make this very clear. Insurance should be your number one stopping ground. Just to clarify, that is after proper communication and after proper documentation and after being a good landlord and the best tenant you can be. Then insurance should be your number one stopping ground for problems. Number two, even if you have a limited liability company, you have to prevent the piercing of the corporate veil, which usually takes corporate and legal experts to help you fight off things like, write this one down, a 30B6 deposition. If you can fight that off as an individual, maybe the LLC is right for you. But let's just leave it there and now flip the script. What if a tenant has a visitor and the visitor slips and falls and the visitor sues the tenant and the owner? Who's going to protect the tenant? Not the owner's insurance policy. This is where it's very important that if you're a tenant, you also consider getting renter's insurance. It's not just to protect your belongings if, let's say, there's a roof leak and all of a sudden your couch and computers get destroyed. It's also to protect you if one of your guests slips and falls and sues you, even if it's not your fault. Now, obviously, for all of these things, as I've said before, please consult an attorney and an insurance agent. I am neither of those. I'm a real estate broker and a property manager. Now, the fourth reason for tenant-landlord lawsuits is a violation of the right of the tenant to quiet enjoyment. Now, this can usually be a much more involved lawsuit. I don't believe small claims can help you other than for actual monetary damages. I'm pretty sure in small claims, you can't go after things like punitive damages, like you were hurt or injured, and now you're looking to claim a certain amount of money to compensate you for that. I'm not sure though. Small claims has a very limited scope, and it's something that you should look up. In fact, if you've had any experience with small claims, I encourage you to leave a comment down below and let me know how your experience was. I'm not an expert on small claims court, but I can tell you landlords should leave their tenants alone, for the most part. And ultimately, if landlords for whatever reason want to enter a tenant's property, they should realistically do so by communicating with the tenant. When I talk to my tenants, I send them a text message. Hey, how would you like to meet on this day? Or is this time better for you? Having that open communication and nice, friendly, and fair dealing dialogue is usually the best way to go. If you have to get to the point where you're going to a property and posting a 24-hour notice on the door that the landlord will enter, this is your notice of entry, the landlord's probably setting up a tenuous relationship, and this isn't going to lead anybody to being happy. It's also important to remember that a lot of landlords can sometimes be very mean because they come across as high and mighty, kind of slimy, you owe me, I'm your landlord. I always like to treat my tenants with mutual respect, and if a tenant comes to me and says, hey Kevin, the stove isn't working, can we get this repaired? I send somebody out right away to handle it. If that still doesn't fix it, like what happened on a recent property I exemplified on YouTube, I will send out a new stove and have a brand new stove installed, because I'll do whatever I can to make sure to maintain that positive relationship between myself and my tenant. Now, when it comes to security deposit deductions, we'll talk about those later, and you'll see that I'm actually a lot more reasonable than some people might think, mostly because if a tenant looks at a landlord, they usually get the perspective of, oh, landlord's automatically going to rip off a tenant. But that's not always the case. Let's talk about that in detail a little later. The fifth source of lawsuits between landlords and tenants are unlawful evictions. Now, this is very common in rent control areas where landlords try to raise rent more than they're allowed to, or sometimes they even do these bait and switch kind of lease term changes where they get a tenant in at, let's say, $1,800 a month for the first year, and then all of a sudden they switch the tenant and they jack the rent up to $2,500, let's say as an example, when lease renewal comes up. Sometimes tenants can argue, and rightfully so, that they've been unlawfully evicted because of an unfair rent increase or some kind of reduction in services that the landlord had promised. California recently passed a statewide rent control law, which actually establishes that if a tenant has their rent raised more than a certain amount, or a tenant is for some reason evicted essentially without cause by a landlord because, again, they raised the rent or they said they wanted to move into the property or whatever it is, the landlord is now required to provide the tenant 1 month's rent in compensation for the fact that the tenant has to move. Now, obviously, in lower priced rentals, that's still not going to help very much, and that's why a lot of unlawful eviction, rent control related cases end up in court. Now, in this case, most of the time, it's the landlords that messed up. I personally never like to raise the rent on my properties more than 1% to 2% per year. That's it. I usually don't try to profit more. I just try to keep up with inflation, and that's it. Especially if a tenant is a great tenant, I won't not raise the rent because with inflation, that basically means you're taking a rent decrease, but I'll always try to stay with inflation, which is historically low. If a landlord manages properties like that, the odds of them running into unlawful eviction lawsuits is generally relatively low. This one should be obvious. Discrimination, and nobody should discriminate against sex, age, religion, sexual orientation, or any of the other protected classes, which there are many. Pretty much the only thing that landlords, and this might even be the wrong word for it, but pretty much the only thing a landlord should ever discriminate on, it's not even necessarily a discrimination of a person, but really the only thing a landlord should ever consider discriminating on is a credit score. Anything that even remotely touches any of the protected classes is a big red flag for fair housing related complaints, sanctions, fines, and lawsuits. So stay away from any form of discrimination. And this works both ways. This is where it becomes very important for a landlord to document how they screen tenants and always follow a written criteria. The seventh source of lawsuits between landlords and tenants is landlords not properly providing the security deposit refund to a tenant within the allotted time frame within that state. In California, for example, a landlord has 21 days to not only provide the tenant their security deposit back, but if there are any deductions, those deductions must be itemized, must be reasonable, and must be documented with receipts or good faith estimates when receipts aren't possible. And then even then, when those receipts become available for those good faith estimates, the landlord must send that receipt to the tenant within 14 days after receiving that receipt. This is why it's much better for tenants to wait for landlords to follow the law in terms of security deposit refunds than live out the security deposit. Mostly because a lot of lease agreements actually say living out the security deposit is a violation of the contract, which doesn't look good. Now let's get to the biggest source of frustration for both sides and probably the most common reason people end up in court. Security deposit deductions. First things first. In California, at least, a landlord is required to do what's known as a pre-move-out inspection with the tenant to give the tenant the opportunity to repair damage. For example, the last tenant to move out of one of my rental properties was told, hey, there are some larger than normal nicks and damage to some door frames and the closet doors that actually look like holes larger than the size of a quarter, and these should be repaired, otherwise they might be security deposit deductions. The tenant filled and spackled these holes and made them look pretty good. The tenant won't be deducted for that damage because I told them about it, they fixed the damage, now there won't be a deduction. This is why the pre-move-out inspection is so important. But not only that, if a landlord forgets or just doesn't do a pre-move-out inspection, that could actually be a case-winning argument for a tenant. Hey, I was never offered a pre-move-out inspection. So if your landlord in California didn't offer you a pre-move-out inspection or tell you things that you should repair, you might have a case against getting all of your security deposit back. Obviously, talk to an attorney. Now, the most common forms of deductions are as follows. Number one, ordinary wear and tear. And guess what? You can't deduct for ordinary wear and tear. That is, let's say a tenant put a couch against the wall and that couch moved back and forth a little bit and ended up leaving some damage on the wall behind that couch. That would be deemed ordinary wear and tear. Or a carpet is a little bit more worn in a commonly walked through hallway leading to the bedrooms. That would be ordinary wear and tear. And the tenants can't be held responsible for ordinary wear and tear. This is a very risky area for landlords to try to deduct from, and this is oftentimes where landlords end up getting screwed. They deduct for ordinary wear and tear items, and tenants usually win those cases. The second type of deduction might be a useful life proration. For example, let's say a landlord installed a 10-year lifespan carpet, and then the tenant introduced a dog without getting permission from the owner. Now the dog, after 2 years of living in the property, ruins the carpet. This means the carpet only lasted 2 years when it was supposed to last 10. Let's say the carpet cost $1,000. The landlord might have cause for deducting 8 out of 10 years of that carpet's useful life, which is now no longer functional or no longer useful, from the tenant's security deposit, which means the tenant might have to pay $800 worth of that carpet. Now, some landlords will charge the full $1,000, and that's a great way to get sued. It's very important that the lifespans of the product when using this sort of useful life approach are reasonable, are documented, and the work is evidenced with receipts. And the tenant is proven to have actually done the damage to the property using the proper documentation we talked about earlier. Now, I'm going to come clean about a recent mistake that I made. I went through a property and I was so excited to use this shooting macro lens on this rental 1DX camera that I put this into the garbage disposal of a property a tenant just moved out of. And I somewhat implied that it was the tenant's fault that garbage disposal was rusty. And that was because when I look at our garbage disposal, it's not rusty. But then I did a little bit of research and found out I was wrong. Here's the thing about garbage disposals, and then we'll keep going on this sort of lawsuit thing, and we'll talk about some commentary as well that's coming up to really help get to the bottom of this. A galvanized steel constructed garbage disposal might only have a useful life of 2 to 3 years because they rust out. So that garbage disposal is probably at the end of its life. We might have to replace it. Now, the next time I go to replace a garbage disposal, I'm going to install a stainless steel constructed garbage disposal. These cost about $100 more, but their useful life can be upwards of 10 years because they don't rust like that one does. Now let's talk about another example where I also got a lot of heat, and this is a common misunderstanding when it comes to rental property. In about April of 2019, I installed a brand new stove. The stove cost about $575, and the install for that was somewhere around $250. Anyway, I installed that to replace what was a pretty clean and functional stove that just had one of the burners stop working. But I didn't want the tenant to be inconvenienced at all, so I provided a brand new stove. Now, obviously, the tenant is welcome to use the stove as much as they want. Much like if I lent you a car and said, hey, you're welcome to borrow my car, just do me a favor, I just had it cleaned, bring it back to me clean. I don't care what you do with it, just bring it back clean and not damaged. That's it. Well, in this example, I basically got my car back with a clean windshield, and the rest of the car looked like it was just in a mudding competition. That is, the hardest areas within the actual oven were very oily and greasy and dirty. A lot of people think that cleaning an oven like this is as easy as just turning on the self-cleaning oven feature. Unfortunately, it's not. Usually ovens, especially the metal grates, which is one of the reasons I am sick and tired of gas appliances, and I much prefer induction, but nobody else does, so we're stuck with the gas. But the problem with this stuff is you usually have to soak the grates in ammonia, you usually have to put in a lot of elbow grease into the actual racks and the undersides and the corners, and cleaning a stove thoroughly could take somebody 1 to 3 hours, depending on how much grease buildup there is. This particular stove, for only being 6 months old, has a significant amount of grease on it. Now, obviously, I would never deduct from a tenant the cost of the stove, but it would be fair for me to hire a cleaner at maybe a rate of $20 an hour to clean it and deduct $60 or something very reasonable to have that stove clean. California law provides that if a property is provided at a certain level of cleanliness, the landlord can require it be returned in the same condition. It doesn't have to be better, but if it's worse, the landlord is allowed to make security deposit deductions to bring it back to the clean state. Obviously, a stove that's brand new and crystal clear to a stove that's kind of nasty is a big difference, and it needs to be cleaned because when the next tenant comes along, it wouldn't be fair for me to give the next tenant a dirty stove. But I also shouldn't be responsible for having to pay for somebody else's cleaning. Now, this still struck a nerve because some people felt, greedy landlord, slimy landlord deducting $60 for cleaning. Why doesn't the landlord just clean it themselves? Well, unfortunately, that's not how business works. And people think that that means I might not be a charitable person, but in reality, I'm trying to educate both sides, landlords and tenants. Tenants, if you want your deposits back, clean things properly. Landlords, if you want to run a business appropriately, make sure you document the clean condition before and afterwards. These are educational tools for everybody to learn. But obviously on YouTube, things can quickly devolve into, well, you should be donating to the tenant because they're helping you pay down the principal on this house. And we go into this sort of long, extended debate on landlord versus tenant or wealthy versus poor. And honestly, it's quite ridiculous because the bottom line is, I'm trying to exemplify property management principles. Look, I'm a big believer in donating and charity, but the bottom line is, the law is very clear. If windows are provided dirty, the tenant can return them dirty. If windows are provided clean, the tenant should return them clean. Rain or shine, the tracks in this property that I last rented out, they were provided to me dirty, and it's not fair for me to give the next tenant dirty windows. Now, while obviously I didn't convey this as well as I could have in my last video, for which I apologize, hopefully this adds some clarity. But let's get into some course members' very specific and really, really good questions about tenants and the law and preventing lawsuits. Some of these are really, really exciting. Now, Emerson and Guess Who provided questions that come up a lot. And the question is, what do you do if you have an illegal part of a house, like an illegally added half bath or a kitchenette or something that's not technically supposed to be there? Should you bring that to code before renting it out? And usually my response is, first things first. Was anything structurally changed? Now again, I can't provide legal advice and I can't tell you you're not going to get sued if you follow my advice. But if things were structurally changed, I wouldn't rent out the property until everything is permitted and up to code. In fact, I probably wouldn't rent out the property unless everything is legal and up to code, whether it is added square footage or not. But realistically, if there's an added toilet and an added faucet, for example, or there's an added stove and a licensed plumber installed the gas line or hooked up the stove and hooked up the faucets, usually, at least I believe, your risk should be pretty minimal. Though keep in mind, if a tenant finds out that there are illegal changes to a property, they now get landlord leverage over you. That is, they could end up filing a code violation complaint against you or holding that over your head if, let's say, they want you to waive a late fee or whatever. It could just be a messy day for you. And if things weren't structurally changed, you gotta ask yourself, what is it going to take to permit that half bath? However, on the flip side, sometimes it's illegal to add a kitchenette and you're never gonna get a permit for it. And that's where you just have to evaluate that risk yourself. I always recommend consult your insurance company, and sometimes it's even a good idea to talk to the tenant about that and see if the tenant is willing to accept the property the way it is without the permits. Although this can sometimes set up the red flags of now the tenant's aware that it's illegal. Ultimately, you have to make your own decision. Which direction do you want to go? Do you want to go the permit direction? If you do that, unfortunately, you might have inspectors crawling around the entire property. And on the flip side, maybe you don't do anything, but in that situation, I highly recommend at least you have licensed contractors working on those products. Now, Ed asks, is there insurance to help mitigate the cost of a tenant lawsuit? We've already talked about some forms of tenant lawsuit insurance, your regular sort of liability insurance, but there are actually different types of insurances that if you use a property manager, you can sign up for things like eviction insurance or other types of insurance, which can be really useful to someone who's especially a newer landlord. Another question came up from somebody wondering, hey, at what point, here, Nick's Eye says, how many units do you suggest somebody have before they get a property manager? I usually recommend people get a property manager when they start, because that's when you're most unfamiliar with real estate, you're most unfamiliar with the laws and rules and how to get contracts going. If you think about it, when you first hire a manager, you're kind of learning from that manager. But oftentimes, that is not an affordable solution for everyone. So if you need to manage properties yourself, go for it. Just do whatever you can to be as educated as possible. Now, Derek wants to know about specific clauses that can be put into a contract for ensuring a tenant leaves a property as they should. And this also relates to some comments that were coming up in the public YouTube. Some people thought that in my last lease agreement, I snuck in that the tenants were required to clean the windows. Even if I didn't mention anything, California law provides that the tenant should return the property clean, including the windows. Except what we do, because a lot of people aren't aware of that, is we actually have a sort of bullet or numbered addendum that we clearly read to our tenants, and we'll say things like, hey, just a reminder, you are required to have the windows professionally cleaned. Be sure to read through the addendum at the end of your lease. And we'll say that when they sign initially, we'll say it during the pre-move out inspection, and we'll bring it out again later. In fact, if you go through my YouTube videos, you'll see that on video, I have told tenants, here's a reminder, please remember to look at that last page of your lease because it outlines your responsibilities upon move out. So saying things like, tenant is required to have windows professionally cleaned upon move out. Windows were provided in a professionally cleaned manner with the tracks cleaned, and a receipt was provided to the tenant. That is a very reasonable thing to say in a contract. And as long as a tenant reads that and is aware of that and is reminded of it, I don't see any issue with holding a tenant to, well, their end of the deal. Now, Pseudosystem has a question here that says, should tenants have general access to the attic and crawl space as they see fit, or should anything be explicitly restricted? I usually, when I rent out, let's say a single family, I won't restrict any access to any part of the property. If they rent the house, they get the house. They want to go in the attic, have at it. But there are times, especially on multifamily real estate, where if there is a common attic space, yeah, there would be restrictions or prohibitions against a tenant accessing these areas or storing things in these areas. And usually there are sections and clauses in a contract related to storage. Now, John W. says it best. He's had 2 evictions out of the last 13 tenants he's had over the course of 10 years in Oregon and Washington. And he suggests that he's learned the value of screening hard in the first place. And I think this is a really good point to end it on. We'll continue to answer questions and have a dialogue within our group Discord. By the way, for everybody who's made it to the end of this video, I want to invite you to this Discord channel. I've recently divided this Discord channel into a course members only section for every single course that somebody might be a member of, and a public section. So if you join the Discord and you want to be part of sort of the general real estate discussion or stock discussion or general discussion, I've just opened those channels. You're welcome to join. You don't actually have to pay for anything, and you could join the public channels. You won't necessarily see this discussion about tenants because it is within the investing and property management channels, but hey, at least you can come join our Discord and have a dialogue. We'll see you there. Thanks so much for watching, and until next time.